Okay, this is some warm-up. We'll be reading at 200. This is from a Supreme Court of California case. I don't know when the date was, but it's Tomas Verano Cruz. And we're like in the middle of it here for the record. Defendant further seeks to argue that the statements he gave were themselves involuntary. The motion challenging the statements below, however, was based solely on an asserted Miranda violation. As a consequence of the issue not having been raised below, the parties had no incentive to fully litigate this theory, and the trial court had no opportunity to resolve material factual disputes and make necessary factual findings. Accordingly, the claim of involuntariness of defendant's statements and confession is not preserved for appeal. Assuming for purposes of argument that the claim of involuntariness of the statements and confession is properly before us, we reject it. The test for determining whether a confession is voluntary and whether the questioned suspect's will was overborne at the time he confessed. A finding of coercive police activity is a prerequisite to a finding that a confession was involuntary under the federal and state constitutions. No coercive police activity is shown on this record. Defendant was not handcuffed or restrained while in the interview room. No guns or weapons were present. He was offered food and drinks, which he accepted, and his older brother, Joaquin Cruz, was permitted to see him. Defendant does not allege that any improper promises or threats were made, and we see no evidence of any other form of coercive police activity that would support a finding of involuntariness. 3, examination of peace officer personnel files. Defendant next claims the trial court erred in denying him discovery of the confidential peace officer personnel files of Shasta County deputies Buck Dykes and John Corelli. The declaration in support of the motion, which also sought discovery of Deputy Perigo's confidential personnel files, alleged on information and belief that complaints of aggressive behavior, acts of violence and or attempted violence, acts of excessive force and or attempted excessive force had been lodged against the officers. A hearing was conducted on the motion. County counsel appeared and opposed it, arguing the moving papers and declarations in support of the motion inadequate, and that deputies Dykes and Corelli were not even present when the defendant was arrested for this offense. She further represented to the court that she had reviewed the files of all 3 officers and that there is nothing in those files that even pertain to anything that defendant and co-defendant Estrada appear to be looking for. The trial court denied discovery of the confidential personnel files of deputies Dykes and Corelli, observing that the moving papers do not establish a basis on which the records of either Dykes or Corelli would be appropriately discoverable under the circumstances of this case. There is no basis in the moving papers on which a conclusion can be reached that their past conduct would in any way have anything to do with matters or material that might in any way be helpful to the defense in the case. The trial court agreed to conduct an in-camera review of Deputy Perigo's confidential personnel file going back 5 years. Following its review, the court announced that Deputy Perigo's files likewise contained no evidence of any complaints. A motion for discovery of peace officer personnel records is addressed solely to the sound discretion of the trial court. A review of the lower court ruling is subject to the abuse of discretion standard. We find no abuse of discretion on this record. In criminal cases, the court retains wide discretion to protect against the disclosure of information which might unduly hamper the prosecution or violate some other legitimate governmental interest. Nor could defendant demonstrate prejudice on a finding of error, as county counsel's representations that the hearing on the motion below and the trial court's statements upon completion of its review of Deputy Perigo's confidential personal files together make clear that no information in the nature being sought through the discovery motion was to be found in any of the 3 officers' personnel files. 4, admission of photograph of victim. Defendant contends the trial court erred by admitting Exhibit 62, a photograph depicting visible injuries to the face of Deputy Perigo, including blood. The prosecutor offered the photograph to demonstrate that the deputy was still alive after he was shot in the back of the head and his patrol car crashed, and then shot a second time in the neck. The defense objected to the admission of the photograph as inflammatory and irrelevant. It was not irrelevant. A crime scene photograph is relevant and may be admitted where it corroborates or clarifies the coroner's testimony regarding the cause of death and condition of the body. Here, the trial court questioned Dr. Joseph Tripoli, the Shasta County medical examiner who conducted the autopsy of the victim, before ruling the photograph admissible. Dr. Tripoli indicated that the particular photograph in question best depicted the bluing of a subcutaneous contusion and would thereby support his conclusions and serve to demonstrate to the jury that Deputy Perigo was still alive when shot a second time. Nor was the presentation of the photograph unduly inflammatory. The trial court took steps to address defendant's concerns in that regard, ordering that the photograph only be made available for viewing by the jury during the brief time that Dr. Tripoli was testifying and actually referring to it. Neither error nor prejudice has been shown. 5. Admission of threat to kill Deputy Dykes. Defendant next asserts the trial court erred in admitting evidence of his prior threat to kill Deputy Dykes by shooting the deputy in the back of the head. There was no error in the admission of such evidence. As defendant concedes, this court's decision in People v. Rodriguez, 1986, 42, Cal 3rd, 730, specifically holds that a defendant's prior threats to kill a police officer may be admitted on the issue of intent when that defendant subsequently does kill a police officer. The prior threat to kill a deputy by shooting him in the back of the head was manifestly admissible to show defendant's state of mind at the time he fatally shot Deputy Perigo in the back of the head. Evidence of the prior expressed threat to use force or violence was also properly admissible at the penalty phase as an aggravating circumstance under Section 190.3, Factor B. We have lights again. And now we have number 6, admission of testimony of Bernard Sanchez. Defendant next contends the trial court erred in permitting witness Bernard Sanchez to testify regarding an adoptive admission by defendant that supported the finding that he shot Deputy Perigo. Sanchez, an employee at the rice mill, testified defendant and Estrada walked into the packing building where he was working sometime prior to their surrender to police. Defendant still had on his handcuffs. Sanchez overheard another worker, Guadalupe Duran, ask Estrada if they still had the murder weapon. Estrada replied the gun was hidden in the alfalfa. Duran asked which one of them had done that wicked thing, a reference to the murder of Deputy Perigo. Estrada motioned with his head toward defendant, who made no response. Defendant then stated that nothing would have happened if the lady had not called the police on them. Defendant asked the workers for money to buy clothes so that he and Estrada could flee to Oregon. Defendants claim that Sanchez's testimony was untrustworthy and violated his rights under the Confrontation Clause of the Federal Constitution must be rejected. Evidence Code Section 1221 provides evidence of a statement offered against a party is not made inadmissible by the hearsay rule if the statement is one of which the party, with knowledge of the content thereof, has by words or other conduct manifested his adoption or his belief in its truth. As was explained in People v. Preston, 1973, 9 Cal 3rd, 308, if a person is accused of having committed a crime under circumstances which fairly afford him an opportunity to hear, understand, and to reply, and which do not lend themselves to an inference that he was relying on the right of silence guaranteed by the Fifth Amendment to the United States Constitution, and he fails to speak, or he makes an evasive or equivocal reply, both the accusatory statement and the fact of silence or equivocation may be offered as an implied or adoptive admission of guilt. I'm going to try and speed up a little bit here. Defendant is wrong in suggesting the statement was admitted under the statement against penal interest exception to the hearsay rule. It was clearly proffered and admitted as an adoptive admission under the Evidence Code Section 1221. Moreover, it is well settled that an adoptive admission can be admitted into evidence without violating the Sixth Amendment right to confrontation on the ground that once the defendant has expressly or impliedly adopted the statements of another, the statements became his own admissions and are admissible on that basis as a well-recognized exception to the hearsay rule. Defendants claim that Sanchez's testimony regarding the adoptive admission violated his rights under the Confrontation Clause is therefore unavailing. We have further considered and must reject defendant's claim that he received no notice at all of Sanchez's proposed testimony. The record reflects that defendant did receive discovery detailing Sanchez's presence at the scene of the conversation in question and the inculpatory statements made at the time, and further reflects that Sanchez's name was on the prosecution's witness list. Indeed, defense investigators had sought to contact Sanchez to discuss his testimony. In any event, even were we to find that Sanchez's testimony regarding defendant's adoptive admission that he killed Deputy Perigo was erroneously admitted, there could be no prejudice since defendant admitted as much in his own confession shortly after his surrender to authorities. Okay, let's read that segment again. This is 210 for the record. Defendant is wrong in suggesting the statement was admitted under the statement against penal interest exception to the hearsay rule. It was clearly proffered and admitted as an adoptive admission under Evidence Code Section 1221. Moreover, it is well settled that an adoptive admission can be admitted into evidence without violating the Sixth Amendment right to confrontation on the ground that once the defendant has expressly or impliedly adopted the statements of another, the statements become his own admissions and are admissible on that basis as a well-recognized exception to the hearsay rule. Defendants claim that Sanchez's testimony regarding the adoptive admission violated his rights under the Confrontation Clause is therefore unavailing. We have further considered and must reject defendant's claim that he received no notice at all of Sanchez's proposed testimony. The record reflects that defendant did receive discovery detailing Sanchez's presence at the scene of the conversation in question and the inculpatory statements made at the time, and further reflects that Sanchez's name was on the prosecution's witness list. Indeed, defense investigators had sought to contact Sanchez to discuss his testimony. In any event, even were we to find that Sanchez's testimony regarding defendant's adoptive admission that he killed Deputy Perigo was erroneously admitted, there could be no prejudice since defendant admitted as much in his own confession shortly after his surrender to authorities.